So I'd like to leave some time for question and answers, which means we must now go to talk about the 3 major new court appearances pursuant to the new rules. Update to court appearances. These are the newest things, family management conferences. By now, some of your clients may have already attended some of these either in person or via MS Teams virtually, essentially on kind of Zoom. And these totally replaced the original first appearances where it was very confusing and nobody knows what to expect at them. And there's like 40 other people sitting at the court registry and you're waiting all day and not sure what's going to happen. These are now specifically arranged. Time is set aside for your client. There's less people at those remand dates, and the judge would have had the opportunity to at least go through your application and any counters and replies. And this is the typical first step, is your clients attend the family management conference. Now, the registry will help schedule it. Everybody will typically get notices of these. At a family management conference, the judge can assist the parties to identify some of the issues that are about to be hopefully resolved. They can explore some options to resolve those issues, such as, alternate dispute resolution methods, etc. They can make case management orders or directions to make sure the case is then ready for the next step. So let's say the next step is everybody's going to go to a settlement conference. Then the judge might direct, hey, person B, you haven't filed your financial statement yet. You got to file your financial statement, within 30 days. So that's the type of direction dealing with process that can help the parties, move the file along. Now, the biggest change is this next paragraph. Make interim, which are temporary orders about family law matters without consent. This has not typically been the case in years prior. This is now specifically something a judge can do at family management conference, order interim child support, order interim parenting plans, order interim things about spousal support. And this is one of the key reasons why your client needs to be aware of 2 things. 1, they must have done their initiating forms with enough detail if they're requesting stuff or defending against things. 2, they must be prepared to kind of advocate for themselves at this family management conference if they don't have a lawyer. It's not totally going to be administrative. It used to be that by and large, first appearances are entirely administrative. Oh, okay, group 2, you guys next step, just file your financial statement, go to your case conference would have been, a normal event back in the day prior to May. Now, you attend a family management conference, essentially anything can happen interim wise. The judge can make factual findings that leads to a real parenting arrangement being set in stone temporarily, I suppose, until the next time you get in court. But when you really think about that, the next time you get in court might be like months from now. So whatever interim parenting arrangement isn't going to last for 4 days. It's going to last for months. The support that's in place will last for months until, say, the next settlement conference or a hearing. So be very, very careful in preparing your clients. If they've gone to court before at a first appearance and they thought that was how it's going to go, this is not how it's going to go. Like, it could be, lots of things could happen at these, and they need to be prepared to make submissions on the fly, to answer the judge's questions, to defend their position. Lots of robust things could happen at these that are not by consent. Having said that, of course, the parties, if they do consent to things, can make consent orders at family management conferences. And if the other side just squarely doesn't show up, you could ask for an order in the absence of the other party. If Katie had a question about whether or not you would go straight from filing to a family management conference, you could ask for the shortening of time if there is a like the other forms that we talked about, if there was like a priority matter, or you're looking to shorten the time or do it without notice, you'd have to do one of those forms and see if those get approved. But here, the registry essentially tries to schedule the next available family management conference once the usual reply timelines have expired. So you get a date by working with the registry and the judicial case manager to find kind of the next available family management conference date. And I see there was one other question. Steve had a question: would using Supreme Court to address child support matter be usually quicker than provincial court process? Great question. Maybe is my answer. And then maybe is because there's a mandatory requirement in Supreme Court for a judicial case conference. And in order to get out of that, you'd have to make a requisition and do a specific waiver of that mandatory process. Now, obviously, if you're not successful, you're probably not faster. If you were successful, you'd probably land about the same timeline, I would say, between getting a date for a family management conference and getting a Supreme Court Chambers Day for child support. I'd say kind of roughly maybe about the same. Having said that, I suppose it would depend registry to registry. You know, some registries have chambers sitting every day. In Cranbrook, there's an assize every month, you know, approximately. So in Cranbrook, it probably not be faster in some instances. It also depends on, like, is the next Chambers Day a week from now, or is it like a month from now? So it's uncertain for sure. I think you could get into Supreme Court faster sometimes, perhaps if you complete the full waiver process, but maybe not. Timeline for reply is generally still 30 days after service, but it states on the reply form and also on the application form for that specific application how quickly you have to reply. So on to the second to last topic, which is the family settlement conferences. These are previously known as family case conferences. Everybody is really familiar with them. They are essentially some type of private conference mediation between the judge, the parties, and if they have counsel, with counsel. The judge will explore the dispute, try to figure out some common ground between the parties, and talk about the needs of the children, talk about some potential parenting arrangements. The judge will do their best to help parties reach an agreement. Everybody will have a chance to talk about what's important to them and what their problem with the situation is. And the judge could also provide some comments about the strengths and weaknesses of each party's case, and provide their feedback on kind of how things are going. Judges could also make conduct orders and process orders, which move things along, like file your financial statement, or talk about the witness list and things like that, to, if they are not going to settle, to help guide them to trial. The final thing is a trial preparation conference, which is new. These are short court hearings with a judge to discuss how the trial will proceed, how many witnesses everybody is calling, the length of the trial, and the judge will help explore any additional steps that may need to be taken, like exchange of exhibits, exchange of what we call will say statements for witnesses, such as, like, okay, you've listed, you know, Amy Jones as your witness, you know, this person doesn't know who Amy Jones is. What's that witness about? Are they a counselor? Are they a babysitter? So those are called will say statements, and a judge could ask you to exchange those ahead of the trial. And of course, as usual, what hasn't changed is, of course, after trial preparation conference, you're going to have your final hearing/trial to deal with all of the outstanding matters. Of course, there's also hearings about interim things like the priority parenting matters. Those will go to a quick hearing without deciding on all the other issues. So those are all the same as before, regular hearings and regular trials. And that leads to the end of the presentation. I've left about 10 minutes for questions in case anyone else have questions about any of the things that we've covered today. I know it's been a long 2 hours, lots of information. Believe it or not, there are actually tons of little things about the rules, about, expectations around service, etc. Things that have changed that are not covered today that you'd have to refer to the rules about. Oh, and we have a big question from Aaron. If one party files family matters in the Supreme Court, is there a form the other party can file to get the case heard in provincial? Good question. So if a file has already been filed in Supreme, you got to answer in Supreme. You could, at that point, ask the Supreme Court judge to move the file to provincial and make your submissions there. But you can't just start another action in provincial unless you've successfully talked to the Supreme Court judge, decided there that the file be downgraded and transferred to provincial court. You can't just start alternatively like your own action somewhere else. You have to answer the Supreme Court action if party A has already filed in Supreme on the same matters, same parties, everything. Supreme Court seems to be much more expensive, and most legal aid lawyers in our area do not take on Supreme Court cases. Yes, Supreme Court is expensive. For sure, because Supreme Court, you're dealing with like asset division and all that as well, frequently, that it's much more complex, a lot more is dependent on it. Sometimes I've seen that where parties have settled on all of their asset division, if the only matter left is the relocation of a child, for example, that parties can jointly request for the file to be transferred to provincial court for all purposes, just to deal with the remaining parenting matters, so it's cheaper. Or one party could make that suggestion. Although that's more atypical, that, if both parties aren't in agreement, the file will likely probably stay in Supreme. And Supreme also have other consequences, like cost consequences if you lost, which are not part of the usual provincial court regime, which, many people have to be mindful of, that if they took an unreasonable or a non-winning position, that they could get a cost award in Supreme Court. So I hope that answers that question. Oh, thank you. One person said it was a very informative 2 hours. I hope it was. I mean, we squeezed in a lot of information. And hopefully that was a practical explanation of how to help your clients in supporting them with the new form and the new process that is part of provincial court in BC. And
no, thank you, Karen. It was very, very informative, and you explained it very well. Me and Alessia and Sarah, we were talking on the chat that you should be a teacher. It was a very well explained. Every section was so laid out, so good. Very well done. Thank you.
Thank you, everyone.
Yeah. Lots of thank yous are coming to you, Karen, on the chat as well. So it was a brilliant presentation. Thank you for sharing all this, these new rules, wealth of knowledge, while our others are in trial, and you have done an amazing job putting them together.